A software developer shares his unreleased product concept with a potential investor. They sign an NDA. 3 months later, the investor passes on the deal, and 6 months after that, a competing product launches with a feature set that mirrors the developer's exact concept. He believes it's his idea. He hires an attorney to sue. The attorney reviews the NDA and finds that the agreement defines confidential information as trade secrets, as defined under applicable law, a circular definition that the court found insufficient to protect a product concept that hadn't been patented and wasn't registered anywhere. The NDA he relied on protected nothing. A non-disclosure agreement, NDA, is a contract that obligates the receiving party to keep certain information confidential and not use it for purposes outside those authorized by the agreement. An NDA does not protect ideas. It does not prevent someone from independently developing the same concept. It does not apply to information that's already public. And it does not protect you if you can't prove what information you shared, when you shared it, and that the recipient used it in violation of the agreement. NDAs protect documented confidential business information from deliberate disclosure and only from the parties who signed the agreement. There are 2 types of NDAs. A unilateral NDA, also called a one-way NDA, obligates only one party to confidentiality. Used when you're sharing information with a potential partner, contractor, or investor who isn't sharing equivalent information with you. A mutual NDA obligates both parties to keep each other's confidential information private, used in partnership negotiations, joint ventures, or situations where both sides are sharing sensitive business information. For most freelancer-client relationships, a unilateral NDA in your favor is appropriate when you're sharing proprietary methodology, pricing models, or client lists with a prospective client. The definition of confidential information is the most consequential provision in any NDA, and the most commonly drafted poorly. An effective definition explicitly lists the categories of information being protected: financial data, pricing, customer lists, business plans, technical specifications, unreleased products, proprietary processes. Catch-all language, like all information disclosed by the disclosing parties, is often unenforceable because it's overbroad. Courts in many jurisdictions require a reasonable, defined scope. Mark documents confidential when sharing them and maintain a log of what was shared, when, and to whom. This creates the evidentiary record you'd need to enforce the agreement. Standard exclusions from NDA protection are built into every well-drafted agreement. Information that is already publicly known, information the receiving party independently developed without using your confidential information, information received from a third party who wasn't bound by a confidentiality obligation, and information the receiving party is required to disclose by law or court order. These exclusions are not weaknesses, they're the legal boundaries that make the agreement enforceable in the first place. An NDA that tries to protect publicly available information, or information that a party independently conceived, will be invalidated by a court. The term of the NDA, how long the confidentiality obligation lasts, varies by purpose. For trade secrets, perpetual or indefinite terms are appropriate because trade secrets have no expiration. For general business negotiations, 1 to 3 years is standard. For employee NDAs covering standard business information, 2 to 5 years after separation. Courts in some states, most notably California, treat overly broad or long-duration NDAs with extreme skepticism, particularly for employees. California Business and Professions Code, Section 16600, largely invalidates employee non-disclosure agreements that effectively function as non-compete agreements in disguise. Remedies and enforcement provisions determine what happens when the NDA is breached. A well-drafted NDA specifies that a breach entitles the disclosing party to seek injunctive relief, a court order stopping the breach, without having to prove actual monetary damages, which are often difficult to quantify when confidential information is misused. Include a provision that the prevailing party in any dispute is entitled to attorney's fees, and specify the state whose law governs the agreement, typically your home state. Without a governing law provision, a breach dispute could be litigated in the recipient's jurisdiction under less favorable law. Before sharing any information you consider proprietary, in a sales meeting, a partnership negotiation, or an investor pitch, get the NDA signed first, not after. Once information is shared without an NDA in place, the NDA can only protect against future disclosure, not the information already disclosed. Build a habit. Anytime a conversation moves toward business specifics, customer data, pricing, or proprietary methodology, stop and say, "Let me send over our standard NDA before we continue." This is not paranoid, it is professional. Most sophisticated counterparties expect it and sign without friction. What an NDA cannot replace: a patent for a product invention, a trademark for a brand, or a copyright for creative work. If you're worried about someone stealing your product concept, the NDA is a weak substitute for a provisional patent application, which costs $320 for small entities and establishes priority with the USPTO for 12 months while you refine the invention. If you're worried about your brand being copied, a trademark application is the tool. NDAs protect information shared in confidence between identified parties. Registered IP protection protects against the world, including people who never signed anything. An NDA is not a magic shield. It is a contract between specific parties for specifically defined information for a specific period, enforceable only if you can prove what you shared and when. Drafted with a precise confidential information definition. Sign it before you share. Mark documents confidential. Keep records of what you disclosed. For the complementary protections that cover your client work product and your own intellectual property in commercial engagements, the Contracts for Freelancers series covers IP ownership, work for hire, and the provisions that protect your deliverables in every client agreement. An NDA guards what you share in confidence, but your day-to-day client work needs broader protection. Contracts for Freelancers. Part 1 covers what every client contract must include, from scope to IP ownership to payment terms. It is on this channel.